Guess what, ladies and gentlemen? That's right. It's Saturday. That's why I'm here. My name is Scott Reich, and this is Crime Talk. And boy, what a big week it has been. And we have a weekly recap for you here, so you don't have to go looking anywhere else. Watch everything that took place this week in one spot. Have a great day. We'll see you next time on Crime Talk. Let's get to it. Closing arguments in the Rittenhouse case. All right, some people want to talk about the Rittenhouse case, other people don't. Thursday, we went through the jury instructions that the court was going to give, and guess what? Well, the judge made a decision early, and he had dismissed count 6 from the Kyle Rittenhouse charge sheet. What charge was that? Illegal possession of a firearm. Judge Schroeder dropped the charge Monday morning after the state, that's right, the prosecutor, had to concede that the rifle carried by Mr. Rittenhouse on August 25th of 2020 was more than 16 inches. Why does that matter? Well, it's not against the law to carry a rifle if it's above 16 inches. Who would be upset by this? Well, a lot of people seem to be. But guess what? The law was not written by the judge. The law was written by the legislature. The prosecutor had to do it. Now, I'm a little surprised that it took this amount of time for somebody from the prosecution side to actually go and measure the firearm to see if it was, in fact, a violation of the law. Scary, ladies and gentlemen. It was the defense that had to actually measure that and present that evidence. The prosecution didn't even care. Don't you think they'd want to double check the facts? I guess it just doesn't matter. But that's why we have defense attorneys. That's right. Because, well, frankly, when the prosecution says something or state says something is true, you can't assume that it is actually true, because a lot of the time it is not. But at least the prosecution finally agreed on the day of closing arguments that it was not an illegal weapon, even though they went through their entire case saying that it was an illegal weapon to be carried. It was not. What the law did state is that anyone under 18 to carry a short-barreled rifle and a rifle with a barrel shorter than the 16 inches, but it's not illegal to carry a longer rifle in the state of Wisconsin. Now, the prosecution is staking their case on the evidence that the judge warned Monday morning could, well, as he stated it, fall like a house of cards. Now, the judge made his comments as he and the attorneys for both sides finalized the jury instructions to be read to the jury ahead of closing arguments that took place this morning. Well, the judge was referring to the drone footage that shows Rittenhouse pointing his gun at people before he allegedly shoots Joseph Rosenbaum. Well, he did. The question is whether it was self-defense. The defense argued unsuccessfully for the image, blurry at best, and enhanced using an algorithm that the state's expert witness admitted to not understanding to be excluded from the evidence. Judge Schroeder ultimately decided to allow the image into evidence, stating that he would allow the jury to decide what importance to give that evidence to the case. And then today, when the point was raised once more, he warned the assistant district attorney, Mr. Krause in this case, this technicality is not being used to decide which camera I'm going to buy at a store. This is being used to decide whether someone is guilty or not guilty of a crime. I don't want to be meddling or commenting on the evidence, but I will tell you this, assuring that there is a conviction, one or more, assuming that other motions don't contaminate the outcome, if it comes out at some time that the method used produced unreliable results, this is going to fall like a house of cards. So what does that really mean? Well, the judge is the gatekeeper of evidence. And if you recall the testimony, and some of you may have watched it, where their expert witness basically said, hey, things were done with algorithms and, I just tried to enhance it, made some pixels, and I can't really tell you what color it was before, or I can show you what it is now, but I don't understand how it got there, what did it, how it did it, or anything along those lines. Kind of iffy that it should even be allowed in at all, in my humble opinion. But the judge said, I'll allow it. We'll let the jurors give the weight that it deserves. But the judge said, if there's an issue that this turns out to be basically a snake oil salesman trying to say this is what we think it should be at best, he's going to basically throw the case out, particularly if there's some sort of post-conviction relief. So, and obviously Kyle Rittenhouse has resources at his disposal, so there will certainly be some investigation, particularly if there is in fact a conviction. So, I don't know. The prosecution was not exactly endearing themselves to the prosecution. I think they stepped over the line several times in this particular case. So what are the charges that Rittenhouse is actually going to face? First-degree reckless homicide, use of a dangerous weapon. Now, the judge denied a prosecution request for the jury also to be able to be instructed on second-degree reckless homicide. Now, Rittenhouse testified he acted in self-defense when he fatally shot Rosenbaum after the man threw a plastic bag at him and chased him. Now, under cross-examination, Rittenhouse said he knew Rosenbaum was unarmed. He said he was pointing his rifle at Rosenbaum in an attempt to deter him and acknowledged that it was in fact dangerous. Count 2, first degree, recklessly endangering safety, use of a dangerous weapon. It's alleged that Rittenhouse recklessly endangered the safety of Richard McGinnis, a journalist with the conservative Daily Caller, under circumstances that show an utter disregard for human life. Count 3, first degree, recklessly endangering safety, use of a dangerous weapon. It's alleged that Rittenhouse recklessly endangered the safety of an unknown male referred to as Jump Kick Man in court under circumstances that show utter disregard for human life. The man jumped at Rittenhouse at one point trying to kick him, and the teen opened fire. I thought if we were to be knocked out, he would have stomped my face if I didn't fire, according to Rittenhouse's testimony. He fired at the man twice and missed. Now, count 4 is first-degree intentional homicide, use of a dangerous weapon. It's alleged that Rittenhouse caused the death of Mr. Huber, with the intent to kill him in the most serious charge he faces with a mandatory life sentence. Huber swung his skateboard at Rittenhouse after Rosenbaum was fatally shot. Count 5, attempted first-degree intentional homicide, use of a dangerous weapon, referring to Mr. Grosskreutz. Rittenhouse attempted to cause the death of Grosskreutz with the intent to kill him. That's alleged. And after shooting Huber, Rittenhouse testified he saw Grosskreutz lunge at him and point a pistol at his head. Rittenhouse shot him, as he testified. Grosskreutz was wounded, and Grosskreutz testified he pulled out his own firearm because he believed Rittenhouse was an active shooter. Count 6, that's the possession of a dangerous weapon. That was dismissed. Count 7, failure to comply with an emergency order from state or local government. So let's talk a little bit about the jury instructions. Now, the prosecution was requesting lesser included offenses, okay? What does that really mean? Well, let's take the example of, in most cases, you have first-degree homicide, first-degree murder, and you can change the name for various states, but usually you have first-degree murder, second-degree murder, reckless, negligence, right? Those are all lesser included offenses that one could be found guilty, maybe not necessarily guilty of first-degree murder, but they could say it was reckless or second-degree. It was knowing, but it wasn't after deliberation. All right? Usually, okay, and I'm telling you, usually, it is the defense that requests lesser included offenses, right? Because if the defendant is charged with first-degree murder, as a defense attorney, you always want to have the lesser included offenses included in the instructions so it gives the jury an out for a lesser charge. Very rarely, if ever, does the prosecution request lesser included offenses. The prosecution asks for lesser included offenses if, well, their case doesn't go as planned, okay? And here's the defense was saying, we don't want the lesser includeds, we're going all in. And I've done that a couple of times, said, Judge, we don't want any lessers. But guess what? If somebody requests the lesser included offenses and there's evidence to support that, well, there is, because there's a lesser included offense. The mental state is less, it's going to be given. So I just think it's a little ironic that the prosecution is the one asking for the lesser included offenses. That means they're hoping to get something out of this trial. Now, if the prosecutor truly believed in his case, he would say, I don't want any lesser included offenses. I want nothing but the original charges, because that's what I believed when I filed this case, that I could ethically prove to a jury beyond a reasonable doubt. And that's what we have proven beyond a reasonable doubt to a jury. Clearly, the prosecution doesn't think that. Now, the prosecution started their opening statement, and remember, the defense goes, and then the prosecution gets their chance for their final closing. That's just the way it is in the legal system. Those who have the burden, here it's the state, they have the burden, they get to go first, and then they get to go last. Always happens in a criminal case. The first closing by the prosecution was pretty straightforward, which was basically Kyle Rittenhouse, bad man, some sort of carpetbagger coming to this place, to Kenosha, Wisconsin, to cause trouble, looking for trouble. He shouldn't have been there. Oh, and by the way, he lied about being an EMT, so he's a liar, liar, liar. That's the gist of it. He basically also said, and I'm not saying basically, he basically said all the people out there protesting, rioting were heroes, and that they had a right to be there, which I agree, except when they start burning and raping and pillaging and all that other type of stuff that you throw in when you start rioting. But as the jury instructions read, and we talked about these, we actually read them, it doesn't matter why Rittenhouse was present. It only matters the circumstances at the particular time that he fired the shots. All the other stuff, irrelevant. But it's argument. The prosecution argued. The defense, pretty straightforward. Hey, my kid, you may not like him, but guess what? He had a right to defend himself. He was being chased. He was not the one out there looking at trouble. It was all these other people who, and there was testimony, the people had felony convictions, and they testified. That can go to their credibility. The jury can consider that when it comes to their credibility. So we're going to have to wait and see. As of the filming of this, the prosecution has not completed their second closing, and we are just going to have to wait and see what the jury does. And let's face it, ladies and gentlemen, you never know what a jury's going to do. I have lost cases that I thought I was in the money on, and I have won cases that I should have lost. You never know what a jury's going to do. Now, obviously, 12 jurors will deliberate. There are alternate jurors. They will be excused, and they will more than likely be basically told, hey, don't talk to anybody just yet, because if somebody gets sick, we're going to call you next. And we'll have to wait and see whether there's a conviction of some, all, or none of the charges. And obviously, we will try to bring it to you here on Crime Talk when that happens. All right, next on the docket, another big case that we've all been waiting to get started. That's right, Ghislaine Maxwell, the British-born socialite, will get her first sight of potential jurors in whose hands her fate will lie, as they are asked questions to determine whether they are qualified to hear the case. Now, Maxwell, who's pled not guilty to all charges, is accused of grooming and trafficking young girls to be allegedly abused by that guy named Jeff between 1994 and 2004. Ghislaine's family and the alleged victims have both been invited to attend the selection process. Now, in an interview with the Daily Mail, Ghislaine Maxwell stated that she's terrified the overwhelming negative coverage will poison her jury pool and affect the outcome of the trial, despite the evidence which she feels quite confident will prove that she is innocent. And she looks forward to having her day in court to prove that she played no part in that guy named Jeff's crime. Now remember, she doesn't have to prove herself innocent. The prosecutor has to prove her guilty. Ms. Maxwell says that she is absolutely innocent. Now, the potential jurors will get a first chance to see Maxwell in person before they could be hearing the case at length over the next 6 weeks. The court has scheduled selection to last until Friday, suggesting it may be sometime before the final 12 jurors and 6 backup alternate jurors are picked from a pool of some 600 candidates. Over those 3 days, potential jurors will be asked a series of questions aimed at identifying whether they may hold personal biases which rule them out as being able to give an impartial verdict. Opening statements have been scheduled to begin November 29th, meaning it will be some weeks before the prosecution will begin to present their case. We'll see. All right, take a look at this. Smash and grab. That's right. It's a thing. It's a thing in California. It's almost like getting together with friends, heading to the mall. Look, 9 people reportedly entered a jewelry store in Concord, California on Monday and stole jewels after breaking the glass case with hammers. Now, the Concord PD shared a quick surveillance video taken inside the Iceberg Diamonds jewelry store at the Sun Valley Mall. The suspects, all of whom wear masks, gloves, and sweatshirts, can be seen smashing the glass display cases and grabbing what they can. Now, according to the police, the incident occurred at approximately 7:30 p.m. on November 15th, and police say a group of 9 people entered the store and stole the jewelry. Employees who tried stopping the robbers were reportedly kept back by hammer-wielding criminals, and the suspects fled and exited through a Red Robin restaurant before the police arrived on the scene. The police wrote that in their statements that the mall goers reportedly heard gunshots, but that wasn't gunshots. That was actually the hammers breaking the glass. I don't know, ladies and gentlemen, complete lawlessness. Is this what the world has come to? And you can't do anything to protect your property. I don't know. Maybe the law is going to have to change, because I think eventually people are going to get tired of other people taking their stuff without paying them for their stuff. All right, we are back. Let's start the docket for November 18th, 2021. First, Alex Mordoch's defense attorneys, Dick Harpootlian and Jim Griffin, filed a shocking motion on Wednesday asking the court to dismiss the Gloria Satterfield lawsuit. Now, the attorneys are now representing the disgraced Alex Mordoch in multiple criminal cases and lawsuits. And Satterfield's sons have settled with 5 parties connected to the botched wrongful death settlement since their attorneys filed a lawsuit in September. Now, Alex Mordoch is the only remaining party in that case. And in the Satterfield case, Mordoch and others are accused of making off with millions of dollars from a wrongful death settlement. Now, Mordoch's latest charges stem from an investigation by the South Carolina attorneys Eric Bland and Ronald Richter, who uncovered a shocking paper trail showing how Alex Mordoch allegedly stole $3.6 million from the Satterfield's settlement. After Miss Satterfield died, Mordoch recruited his best friend Corey Fleming to sue him on behalf of her estate and convinced Gloria's son to sign over their personal representative rights to Westerndorf's so that the Flemings wouldn't be legally obligated to tell the Satterfield's family what was going on with the settlement. This is all according to Bland. Now, Mordoch's attorneys argue in a motion to dismiss the suit that Gloria Satterfield's sons have been fully compensated for their alleged losses. Therefore, Alex Mordoch, the alleged ringleader, should not have to pay any money back whatsoever. Well, Palmetto State Bank is the 5th potentially liable party to have settled or resolved differences with the Satterfield's family since Bland and Richter filed their lawsuits. The 2 attorneys have recovered more than $6.5 million in total for the Satterfield family 2 months after Bland and Richter filed their lawsuit. Now, Harpootlian and Griffin filed a motion that claims Alex Mordoch is entitled to a credit for more than the $6 million paid to all other settled tortfeasors. And this is interesting because now Alex Mordoch confessed the judgment in lawsuits recently filed by his former law partner, John Parker, and his brother, Randy Mordoch. This would essentially prioritize Alex's debts to Randy ahead of a line of alleged victims currently suing the man whose wife and son were killed in June. So now Alex Mordoch is facing at least 6 lawsuits, 2 for the 2019 boat crash that killed Mallory Beach, 2 for millions of dollars misappropriated stolen funds dating back to 2015, and 2 for unpaid debts. Now, Mordoch has only confessed judgment in Randy Mordoch's case, according to court records. So the proposed remedies that the Mordoch attorneys are seeking in the event the judge in this case has declined to throw the case out in its entirety, which they know isn't going to happen. There isn't a legal basis for tossing the case at this time. Their arguments are basically worthless. The criminal action is obviously brought by the state, so it's not the same action pending between the parties. Second, there's no right to a dismissal because a plaintiff has settled with a co-defendant. The jury would decide if the plaintiff's damages, what they truly are, and if that case, the jury could decide the actual damages sustained, which could be higher than what's actually been recovered to date, particularly when you talk about the mental anguish and all the damages that had to come in the sense of having your money delayed, how that money could have been used more productively if it was invested. So there's still money that can be sought by the plaintiffs against Mordoch in those civil cases. And the court can't say that this case was worth a certain amount. That is a question of fact for the jury. So now, after many efforts in the defense of tossing the case, the attorneys for Mordoch won it clearly as their primary argument. A stay in the civil lawsuit is the best interest of justice and judicial economy. The public interest will be best served by staying the civil lawsuit and allowing the criminal prosecution to proceed without interference. Now, this is not uncommon. Normally, when there is a civil suit and a companion criminal suit, obviously related and intertwined, the civil suit is stayed because the defendant still has a right to assert his Fifth Amendment privileges of self-incrimination. And so it makes no sense for the discovery and everything to go on while the criminal cases are still pending. So we'll see how that turns out. And that is an interesting argument that they're stating that, well, everybody else is settled, so just let me out. And they probably made more money than what they would have received, so let them out. We'll have to wait and see how that turns out. I don't think the court's going to dismiss the case. But you hear about that a lot in criminal cases, all right? A lot of people say, hey, I stole your car, which means I took it without legal permission or justification, and I gave it back, so what's the big deal, right? We see a lot of this now because motor vehicle thefts are, for lack of a better term, almost insignificant misdemeanors these days. And I don't know what rationale people think. Well, I took the car, I've just kind of borrowed it, the car's in good shape, maybe even washed it and put some gas in it. Well, no, that's not the whole point. The point under the law is that you took something without legal permission or justification of somebody else's stuff. You can't do that. So even if you did wash it, did put the car, back in a better spot, the point is you still took it initially without permission. Sometimes people get wrapped up about that. Well, why? The car's back, wasn't damaged. No, it's the mere fact that you took it without permission. All right, let's get to the docket today, November 19th, 2021, a date that will be remembered as, well, the day that Kyle Rittenhouse was found not guilty of all counts after 4 days of deliberations. He is a free man. Now, outside the court, the defense lawyer, Mark Richards, said Rittenhouse was feeling a huge sense of relief at the verdict. And he is on his way home. He wants to get on with his life. Now, as the first verdict was read, and like I said, we brought it to you live. You can watch it here on the channel. Rittenhouse started to shake and fought back tears. But by the end, he could no longer keep composed, basically collapsed and hugged his attorney. Huge sigh of relief. I commented when we were bringing it to you live the fact that the defense attorneys looked very concerned. I heard a conversation with the defense attorney after the verdict, and he stated obviously he was concerned, as I had mentioned, that the longer it goes and with the lesser included offenses that were being offered that the defense objected to, they were quite concerned that the jury would compromise and find Rittenhouse guilty of some charge, whether the original charge or a lesser included offense, and that did not happen. Now, I've already seen in the comments, a lot of people are quite ecstatic about this verdict, and other people are, well, let's say not enthused that Rittenhouse was convicted. Now, as I've mentioned before, hey, the jury has spoken. This is the collective judgment of those 12 jurors, 7 women, 5 men, and 1 African-American gentleman on the jury panel. They take their jobs as jurors very seriously, hence the reason it took 3.5 to 4 days to do their deliberations. They know that this was important, and guess what? They're the ones that saw every piece of evidence. They had an opportunity to go back and listen to, obviously hear the arguments, but look at the evidence again. And guess what? If you can't be upset with Kyle Rittenhouse because the prosecution had the burden of proof beyond a reasonable doubt, which is required under the law, that Kyle Rittenhouse be proven guilty to that standard. The prosecution failed to do that, and the law written by the legislature said that Kyle Rittenhouse was justified in doing what he did. You may not like it, but it's the law. And guess what? There's lots of laws that I disagree with, but it doesn't change the fact. You have to be a realist. So if you're super upset and you think that Kyle Rittenhouse was absolutely guilty, I strongly urge you to go watch every moment of the trial and read the jury instructions so that you can see what the jury had to consider, not just one's political side, their argument that they have immediately decided early on before any evidence was presented in this case. Little intellectual honesty can go a long way. That may cost me a few subscribers or so, but the reality of it is, listen, the system is the system, and whether you like it or not, it's not going to change. Hopefully, nobody goes out and burns anything down. Protest all you want. Just don't harm anybody. Don't destroy any property whatsoever.